Imagine fleeing Britain as a teenager to join one of the most barbaric terrorist organizations in modern history, watching your children die in a Syrian refugee camp, spending years attempting to return home, and then having the European Court of Human Rights formally notify the British government that they are considering your case against the country you abandoned. Now imagine being a British politician who must explain to voters why European judges in Strasbourg might force Britain to take back a woman who joined ISIS, married a jihadist fighter, and lived under the caliphate's brutal regime. Welcome to the Shamima Begum saga, a case that refuses to die, has reignited with explosive force, and threatens to become Sir Keir Starmer's worst political nightmare. Shadow Justice Secretary Robert Jenrick is warning this is a disaster waiting to happen, and frankly, it is rather difficult to argue with that assessment. Quick favor, if you are loving this breakdown of political chaos, smash that subscribe button and hit the notification bell. Over 94% of you have not subscribed yet. It is completely free, takes barely 2 seconds, and genuinely helps us continue bringing you these stories. Cheers if you did. Right, let us dive into this constitutional powder keg. So here is what has happened. The European Court of Human Rights has formally notified the British government that it is considering the case of Shamima Begum against Britain. Robert Jenrick, Shadow Justice Secretary, launched an absolutely blistering attack on the government following this development. His statement was concise, devastating, and politically explosive. The ECHR has notified the government that it is considering the case of Islamic State bride Shamima Begum against Britain. Starmer has said he will always comply with the court, and his Attorney General was her lawyer. This is a disaster waiting to happen. 3 sentences that encapsulate everything terrifying about this situation from a conservative perspective. Let us unpack why this is so politically radioactive. First, the European Court of Human Rights is formally telling the Home Office to justify its decision to strip Begum of her British citizenship. Strasbourg judges have demanded answers on whether the United Kingdom broke human rights and anti-trafficking laws when then-Home Secretary Sajid Javid revoked her citizenship back in 2019. Now, if you are a British voter who supported stripping Begum of citizenship because she voluntarily joined a terrorist organization, the idea that European judges might overrule that decision is absolutely infuriating. It plays directly into every Brexit argument about sovereignty, about unelected foreign judges making decisions for Britain, about the inability to control our own borders and citizenship policies. Second, and this is where Jenrick's attack becomes particularly sharp, Sir Keir Starmer has previously said he will always comply with the European Court of Human Rights. Always. Not conditionally. Not where it serves British interests. Always. That is a politically reckless commitment, and Jenrick is now holding him to it. If Strasbourg rules in Begum's favor, Starmer has effectively promised to comply, which means allowing an ISIS bride to return to Britain against the wishes of the overwhelming majority of the British public. Politically, that is somewhere between catastrophic and career-ending. Third, and this detail is absolutely delicious from an opposition perspective, Starmer's Attorney General was Begum's lawyer. Lord Hermer represented Begum in her legal battles against the British government. Now he is part of the government that must defend against her case. The conflict of interest optics are spectacularly bad. Imagine being a conservative opposition researcher and having this gift land in your lap. The Attorney General previously argued for Begum's return. Now he is supposed to argue against it. How exactly is that going to work? Does he recuse himself? Does he suddenly reverse every legal position he previously held? Either option looks terrible. Home Secretary Shabana Mahmood has vowed to fight European judges over Begum's return bid, insisting the government will continue to defend its position. Earlier this week, Mahmood said the case against Shamima Begum has been litigated by the previous government all the way to the UK Supreme Court, who did not hear the last appeal because all legal questions have been dealt with. It is a robust statement designed to reassure voters that Labour will not capitulate. But here's the problem. The European Court of Human Rights does not care what the UK Supreme Court decided. Strasbourg operates independently of British courts and can absolutely contradict their rulings. That is the entire controversy about the ECHR. It supersedes domestic legal systems, which is why Brexit supporters wanted to leave it. Shadow Home Secretary Chris Philp offered an equally robust response when speaking to the Daily Express. Shamima Begum chose to go to Syria and support Daesh, which is a murderous, violent terrorist regime who brutally murder their opponents and rape thousands of women and girls. People who support that kind of organization are not welcome in the UK. It is deeply worrying the European Court of Human Rights is now looking at using the ECHR to make the UK take her back. The government must fight to keep her out of the country. This case is a further reason why we need to leave the ECHR. Philip is articulating what the vast majority of British voters feel. Begum made a choice. She voluntarily traveled to Syria to join ISIS. She married a jihadist fighter. She lived under the caliphate. And now European judges might force Britain to take her back. The sense of injustice is overwhelming. Begum's lawyers have branded the court's formal communication an unprecedented opportunity to overturn the citizenship decision. From their perspective, this is a major victory, a chance to relitigate a case they lost comprehensively in British courts. The move could lead to a showdown between Strasbourg, who believes Begum's human rights may have been breached, and the UK government. And here is where constitutional theory meets political reality. The ECHR's final rulings are technically binding, but there is no enforcement mechanism. Britain could theoretically ignore a Strasbourg ruling, but doing so would trigger a massive constitutional crisis, potentially require leaving the European Convention on Human Rights entirely, and generate enormous international pressure. Let us revisit Begum's story, because context matters enormously here. She grew up in Bethnal Green, East London, before traveling to Syria at the age of 15 in 2015 to join the Islamic State. She was a child when she left, which her defenders argue should grant her some measure of sympathy. She married a Dutch Islamic convert and had 3 children, all of whom died in infancy. Those deaths are tragic regardless of the circumstances. Sajid Javid stripped her of British citizenship on the basis that she could also claim citizenship in Bangladesh, so would not be stateless. That is a crucial legal point. Under international law, you cannot render someone stateless. Javid's argument was that Begum retained Bangladesh's citizenship through her parents, therefore stripping British citizenship did not violate statelessness prohibitions. Bangladesh has vehemently rejected this claim, insisting Begum is not and never has been a Bangladeshi citizen. Shabana Mahmood's vow to robustly defend the decision to revoke Shamima Begum's citizenship is exactly right. A government source stated, "The Home Secretary will robustly defend the decision to revoke Shamima Begum's citizenship, which has been tested and upheld time and again in our domestic courts. The Home Secretary will always put this country's national security first." That's the correct priority. National security must come first. The UK Supreme Court already ruled this decision lawful. British courts, applying British law, concluded the citizenship revocation was justified. Why should European judges in Strasbourg be able to overrule that? Shadow Home Secretary Crisfield's position for the Conservatives is even more emphatic. She has no place in the UK, and our own Supreme Court found that depriving her of citizenship was lawful. It is deeply concerning the European Court of Human Rights is now looking at using the ECHR to make the UK take her back. This gets to the fundamental sovereignty question. Should Britain be able to decide who holds British citizenship and who poses enough of a security threat to warrant citizenship revocation? Or are those decisions ultimately subject to review and potential reversal by European judges applying European human rights law? The Conservatives argue Begum should not be allowed back under any circumstances. That's a clear, unequivocal position that reflects majority public opinion. Polling consistently shows overwhelming opposition to Begum's return. The British public doesn't want her back. They don't trust that she's been de-radicalized. They don't believe 15 years ago excuses 4 years of actively supporting ISIS. They worry about the security threat she poses and the message it sends if Britain welcomes back ISIS brides who voluntarily joined a terrorist organization. The 4 questions being posed by Strasbourg judges are revealing. They are asking whether the Home Secretary had a positive obligation under Article 4 to consider whether Begum had been a victim of trafficking before stripping her citizenship. This fundamentally reframes the entire case. Instead of asking whether Britain has a right to revoke citizenship of someone who joined a terrorist organization, the ECHR is asking whether UK authorities failed in their duty to protect a trafficking victim. That shifts the entire legal and moral framework. Bernberg per solicitors, representing Begum, claims the court's communication presents an unprecedented opportunity to address significant considerations raised in her case and ignored, sidestepped, or violated up to now by previous UK administrations. They are positioning this as Britain finally being forced to confront uncomfortable truths about safeguarding failures and trafficking. But that's a deeply one-sided framing that treats Begum purely as victim rather than as someone who made choices that resulted in her supporting a genocidal terrorist organization. The reality is more complicated than either extreme portrayal. Yes, she was 15. Yes, there were likely grooming and radicalization factors. Yes, UK authorities could have done more to prevent her travel. All of that can be true whilst also acknowledging that she voluntarily joined ISIS, lived there for years, showed little genuine remorse, and poses a potential security threat. The question isn't whether she was young and potentially groomed. The question is whether that history requires Britain to accept her back despite national security concerns and Supreme Court rulings upholding citizenship revocation. This case has massive implications beyond just Shamima Begum. If the ECHR rules that Article 4 requires Britain to consider trafficking frameworks before revoking citizenship of ISIS members, that potentially applies to other similar cases. It could make citizenship revocation much harder, requiring extensive investigation into whether someone was trafficked or groomed before any action can be taken. It could prioritize individual rights over collective security in ways that make Britain more vulnerable to terrorism. The case also feeds directly into the ongoing debate about ECHR membership. Both Conservatives and Reform UK argue Britain should leave the convention, viewing it as an obstacle to effective immigration control and security policy. Cases like Begum's, where European judges potentially overrule British courts on matters of citizenship and national security, provide ammunition for that position. If unelected Strasbourg judges can force Britain to accept back some of our own Supreme Court rule to remain strict of citizenship, what's the point of having British courts and British law? Labour insists they won't leave the ECHR but will seek to reform how it applies. That's having your cake and eating it too. You can't remain bound by a treaty whilst fundamentally disagreeing with how it's interpreted and applied. Either the ECHR's rulings bind Britain or they don't. If they do, and those rulings force outcomes that threaten national security and contradict Supreme Court decisions, then the treaty itself is a problem. Mahmood's willingness to fight this is politically smart and morally right. She's a Labour Home Secretary taking a tough line on national security, defending British sovereignty, and refusing to cave to European pressure.